Court cases adjourned to the 23rd of October, 2026 for ruling. It's a Friday. It's likely to be virtual. Thank you. Yes, the next case.
Grateful, my lord.
I'm most grateful, my lord.
Yes, call the next case, please. Yes.
Case number 3, NICN LKJ 08-2025 between Mercy O. O'Malley and 6 others, and Kogi State Government and 2 others. Parties absent, my lord.
Appearance, please.
May it please me, Lord. I am A. Onoja. My appearance is for the claimant respondent.
Yes.
With respect to this honorable court, I'm G.O. Salifu. My appearance is for the first and second defendants.
Yes.
It pleases your lordship, my name is Oluwafemi O. Adegboyega. My lord, I appear for the third defendant in this matter. I'm most grateful.
Yes.
Lord, the claimant have the application for extension of time within which to file counter affidavit and written address of counsel in opposition to the third defendant notice of preliminary objection.
Okay, so Mr. Adegboyega, let's just assume that you have not received it, but you are not opposing.
Yes, my lord, that is the position, my lord.
Ms. Salifu, you too, you are not opposing, even though you've not been served.
Yes, my lord, we are not opposing.
Yes, Mr. Onoja.
Thank you, Mr. Sir. May I, with the kindness of court, move the application filed on the 21st day of July 2026 for extension of time within which the claimant respondent do file their counter affidavit in opposition to the third defendant's notice of preliminary objection in terms of the motion paper having not been opposed. Thank you, my lord.
Thank you. Court application granted. The counter affidavits to the third defendant's notice of preliminary objection and counsel's written address filed on the 21st of July 2026 are deemed as properly filed and served.
As court pleases.
Yes.
My lord,
Yes.
My lord, we urge your lordship to deem our process, the third defendant's further and better affidavit and reply on points of law filed on the 10th day of July, was properly filed and served, my Lord. We are most grateful.
Mr. Onoja.
No opposition. No, I am not opposed to that, my Lord.
Mr. Alifu.
We are not opposing, my Lord.
Court application granted. The further and better affidavit in reply on points of law filed by the third defendant on the 10th of July 2026 are deemed as properly filed and served.
As court pleases.
The call, please. So I'm most grateful.
Yes.
Lord, subject to your Lordship's convenience, the notice of preliminary objection is ripe for hearing. All the papers are in. We are ready to take same, subject to your Lordship's convenience.
Mr. Onoja.
I'm ready, my Lord.
We are equally ready, my Lord.
Okay, we can proceed. Yes.
I'm most grateful, my Lord. My
Yes.
Lord,
I think we
think
are
we
waiting
should-
for the first and second.
We shall take the first and second, please.
as the call, please.
As the court pleases.
As the call, please.
Yes, my
Apologies.
Lord.
Yes.
Our notice of preliminary objection is brought pursuant to Order 17 of the National Industrial Court Rules 2017 and Section 2A of the Public Officer Protections Law, Cap 158 of Laws of Northern Nigeria, and under the inherent jurisdiction of this honorable court. My Lord, our notice of preliminary objection is dated 27th of January 2026 and filed on the 17th day of February 2026. It prays for an order of this honorable court dismissing the claimant's suits for being statute bar as stated on the grounds of our application. My Lord, attached to our application is a written address and humbly adopt same as our oral argument. Upon being served with the claimant's written address,
I'm sure
we
you
found-
realize, I'm sure you are reading, I'm writing, so it's easier to
As
read than to write.
as the court pleases, as the
It
court
was
pleases.
filed, also filed alongside as a written address.
Yes, my Lord.
Yes.
And we adopt same as our oral argument. Upon being served with the claimant's written address in opposition to our notice of preliminary objection, we filed a reply on point of law dated 23rd day of March and filed on the 26th day of March 2026. We humbly adopt same.
What
As
was
our
what did the claimant respond with? Is it a written address or a counter affidavit?
It's a written address, my Lord.
Types of
It's a written address.
Yes.
We humbly adopt reply on points of law as our oral argument in urging your lordship to dismiss the claimant's claim as presently constituted. Most grateful, my lord.
When was your reply filed?
Our reply was filed on the 26th day of March, 2026.
Twenty-sixth day of March.
2026, yes, my lord.
Okay. Yes, Mr. Onoja.
Thank you, my lord, sir. In reaction to the notice of preliminary objection filed by the first and second defendant, my lord,
Yes.
the claimant's respondents were served without notice of preliminary objection on the 23rd of February 2026.
Yes.
And they filed their written address of counsel on the 3rd of March 2026 in opposing the notice of preliminary objection.
Yes.
May I, with the kindness of court, adopt the said written address of counsel for the claimants as our argument in this case by urging your lordship to discountenance the purported notice of preliminary objection. And further add, my lord,
Yes.
that Suleiman Dada was referred to in the written address of counsel by the claimants, having been tested by the defendant themselves, it has taken a step further than what it used to do as at the time the written address was filed.
Yes.
Finally, sir, they said
Yes.
notice of preliminary objection, hook,
Yes.
line, and sinker, inure in favor of the claimant, inure in favor of the claimants, having demonstrated that how the so purported called Public Officer Protection Law of Northern Nigeria, it was not an existing law, both at Benue State and Kwara State, as at the time Kogi State was created. And it's on that note that I will urge your lordship to discontinue this notice of preliminary objection. Very please, Lord.
Thank you. Yes, the third defendants, please.
May it please your lordship. My lord,
Yes.
our notice of preliminary objection, the third defendant's notice of preliminary objection is dated and filed on the 24th day of April, 2026.
Yes.
My lord, he prays your lordship for an order dismissing the instant suit, same being statute barred.
Yes.
The notice is supported by an affidavit of 5 paragraphs, also filed in support of the notice of preliminary objection. The written address dated and filed on the same 24th day of April, 2026.
Yes.
My lord, upon the receipt of the claimant's counter affidavit and written address in opposition to the notice of preliminary objection.
Yes.
We also filed a further and better affidavit. The said affidavit was filed on the 10th of July, 2026, and deemed properly filed and served, my Lord, today. Also filed in response to the said counter affidavit and written address
Yes.
is a reply on points of law.
Yes.
My Lord, the reply on points of law was also filed on the 10th day of 2026 and deemed
Yes.
properly filed today.
Yes.
My Lord, we rely on all the paragraphs of the affidavit in support of the notice of preliminary objection, and also the paragraphs of the further and better affidavit. And my Lord, we adopt as our oral argument in support of the notice of preliminary objection both the written address and the reply on points of law. Okay, I think the internet is. Sorry,
Yes.
can my Lord hear me?
Yes, I did hear you.
Oh, my Lord, we urge your Lordship to dismiss, uphold the objection and dismiss the instant suit as same is statute barred, my Lord. We are most grateful.
Yes, Mr. Onoja.
Thank you, my Lord. My Lord, in reaction to the notice of preliminary objection filed by the third defendant,
Yes.
the claimants have filed a 29 paragraph of counter affidavit on the 5th day of May, 2026. And properly deemed today, the 27th day of July, 2026.
Yes.
May I, with the kindness of court, rely on all the paragraphs of the counter affidavit by urging your Lordship to discountenance the notice of preliminary objection, because Kogi State has no limitation law. In compliance with the rules of this honorable court,
Yes.
there is a written address of counsel accompanying the counter affidavit of the claimants.
Yes.
May I, with the kindness of court, adopt same as our oral argument by urging your Lordship to discountenance the notice of preliminary objection.
Yes, thank you.
And further to it, my Lord, sir,
Yes.
they said further and better affidavit deemed today, my Lord, sir,
Yes.
is responding to statement of fact. And the law is simply that you cannot use affidavit to respond to statement of fact. You use pleading to respond to pleading. While the purported reply on point of law falls short of what reply on point of law, as the law referred to there are not existing law in both Kwara State and Benue State, where Kogi State was carved out of. May you please court.
Thank you.
Thank you.
Court case is adjourned to the 23rd of October 2026 for ruling.
As court pleases.
As the court pleases.
Can you call
One
the
more
ex
pray for my
parte application so that I won't delay Mr. Obone? And Mr. Onoja is still with us, but the same thing applies to the ex parte application of both Mr. Obone and Mr. Onoja. Let's call the first ex parte
As
application.
court pleases.
I'm
I think the
withdrawing my
last
own, so
one.
let my own become first. I'm withdrawing my own, my lord.
Yeah, you are withdrawing yours?
NIC and LKJ
Yes, my lord.
15M 2026 between Suleiman Dadao and Kogi State Polytechnic and another.
Okay, Mr. Obone.
Yes, my lord.
Parties absent.
I don't want to further waste your time. Because this application is ex parte, and because there will be an order of court that the garnishes should file affidavits to show cause, and because we are proceeding on vacation, I will not be taking the application because it will be not in the interest of justice to hold the money until we come back from vacation. So I will give you a date shortly after the vacation so that we can give them the 14 days that is appropriate to file the affidavits to show cause. It will not be nice or just to hold the accounts throughout the period of vacation. So your case too will be adjourned till the 23rd of October 2026 for the ex parte application. Mr. Onoja, since you said you are withdrawing
Thank
yours,
you, my
we will
lord.
deal with yours at the
Thank you, my lord.
appropriate time. Or we can just withdraw. Why are you withdrawing it? So that after the ruling, I just move. I sneaked out of a workshop.
Well, we are withdrawing because Suleiman Dada has been reinstated, and the balance the school has undertaken to pay the balance in the course of his employment. So there is no point to go on with it, you know.
Okay, so the ex parte application is accordingly struck out.
As
Most
court
grateful,
pleases.
you know. Okay.
We can call the ruling now. Yes, yes, Lokoja division, the last case. Yes,
My lord, is it the ruling or the other ex parte motion?
we've dealt with the ex parte
Okay,
now, so
my
is the
network.
ruling. Yes,
Sorry, my network went off, so I couldn't
oh,
hear.
sorry about that, okay.
NIC and LKJ 02. NIC and LKJ 02 2025 between Linus Alfred Onu and 142 others and Kogi State government and 4 others. Parties absent, my lord.
Yes. Appearance, please. Appearance.
May it please me, Lord, I am A. Onoja. My appearance is for the claimants. Claimants response.
Yes.
May it please your lordship. My name is Oluwafemi O Adegboyega. My lord, I appear for the third defendant in this matter.
No representation for the first and second.
O.W. Obaidu, my lord, appearing for
the fourth and fifth respondent and appear with
Obaidu.
O.W. Obaidu
yes, my lord.
with
KV Ayobamidele for the fourth and fifth defendant.
court's ruling.
Yes, God, please. I'm not hearing.
Ruling. In
As God,
summary,
please.
the claimant's case is that their names were arbitrarily removed from the payroll of the defendants in 2009, and that consequently they have not been paid their salaries till date. The claimants alleged that the arbitrary stoppage of their salaries by the defendants, without first determining their subsistent employment relationship, is an infringement of the regulations governing the conditions of their service and a violation of their constitutional rights. Being thereby aggrieved, the claimants instituted the present action filed on the 4th of March 2025 and by an amended complaint and statement of facts filed by the leave of court on the 25th of September 2025, the claims severally and jointly against the defendants, the reliefs set out as follows. We have 7 of the reliefs as stated on the face of the ruling. For time's sake, I shall be skipping the reading out of the reliefs. However,
Yes, God, please.
upon being served with the originating processes, the third defendant filed a notice of preliminary objection on the 25th of April 2025. The objection, supported by an affidavit of 5 paragraphs, is praying for an order of the court dismissing or striking out the suit for being statute barred. The written submission of counsel was also filed with a notice of preliminary objection. In reaction, the claimants filed a counter affidavit of 27 paragraphs on the 2nd of May 2025. The objector's reply on points of law was deemed properly filed on the 25th of September 2025. I have proceeded to carefully consider the objection, the facts deposed in the affidavit filed to support the same, and the counter affidavit in opposition. I had also taken due benefits of the totality of the written and oral submissions canvassed by the respective counsel in support of the positions they held. The arguments of the counsel for the third defendant, Oluwafemi Oadegboyega Esquire, is that the claimants commenced the present action against the defendants after the time permitted by the Public Officers Protection Law, Cap 158, Laws of the Northern Nigeria, 1963, hereinafter called the POPL, for filing an action against acts of a public officer complained of, and the time for instituting a case founded on contract had elapsed. Counsel argued that the claimant's complaints or alleged cause of action, as shown on the face of the statement of facts, stems from the alleged removal of their names from the payroll by the defendants and the alleged consequent non-payment of their salaries that arose on the 30th of September 2009 had become extinguished. Just a minute, please. Okay. The technology, something popped up and I have to close that application. So council made reference to the provisions of Section 2A of the Public Officers Protection Law, Cap 158, Laws of Northern Nigeria 1963, POPL, and Section 18 of the Limitation Law of Kogi State 1991, and argued that the alleged act by the defendants was done in pursuance of law, public duty, and authority. Counsel submitted that limitation laws protect defendants from indefinite threat of litigation, and it also prevents the claimants from litigating stale claims after undue delay. The cases of Egbe versus Adefarasi, Mercantile Bank Nigeria Limited versus Fetuku, Ibrahim versus JSC, Edosowam versus ACB, citation also supplied, were cited to buttress his submissions. Counsel finally urged the courts to dismiss the claimant's case for want of jurisdiction being statute barred. Counsel for the claimants, Ewa Onoja Esquire, in reaction, made reference to paragraphs 8, 17 to 22, 48, 50 of the Statement of Facts, and argued that the action of the defendants violates the provisions of Section 33, 36 sub 1, and 44 sub 1 of the Constitution of the Federal Republic of Nigeria 1999. Counsel further argued that limitation laws do not apply to actions founded on rights enshrined in Chapter 4 of the 1999 Constitution. Counsel contends that the defendants acted outside their statutory or constitutional duty and submitted that the right to fair hearing and fair trial is sacrosanct. The provision of Order 3, Rule 1 of the Fundamental Rights Enforcement Procedure Rules 2009, in the case of Elf Petroleum versus Umar 2006, Law Pavilion Electronic Law Reports were cited in support of these propositions. The further argument of claimants' counsel is that Section 2A, Public Officers Protection Law, allows exceptions where there is continuance of damage or injury, that the injury in the instance case is continuing until it ceases, that the claimants are still in the employment of the defendants because their employments have not been terminated and their salary remains unpaid. With reference to paragraphs 23, 24, 25, and 48 of the Statement of Facts, counsel for the claimants further argued that acts founded from malice, abuse of powers, illegal actions of officials, and or wrongful actions such as arbitrary withholding of salary by the defendants, as in the instance case, does not enjoy the protection of the limitation law, and also argued that the Limitation Act or law is inapplicable to cases founded on contracts. The cases of AG Rivers and AG versus AG by Helse, the case of Nestelo Gateway Group Limited versus Judicial Service Commission, FCT Abuja, the case of RMAFC and Johnson, the case of KSJSC versus Tolani, Ibeto Cement Company Limited versus Attorney General, Lagos City Council versus Ogunbiyi, citation also supplied, were inter alia cited to support his propositions. Counsel finally urged the court to dismiss the objection and hold that the claimant's case falls within an exception to the applicability of Section 2A of POPL, as sufficient facts have been disclosed by the claimant that the actions of the defendants are arbitrary, an abuse of power, mala fide, unlawful, without semblance of legal justification. Now, the preeminent status of jurisdiction in the scheme of legal proceedings is well ingrained in our jurisprudence. One will therefore be restating the obvious that jurisdiction is the first test in the legal authority of a court, and its absence disqualifies the court from determining the substantive issues submitted to it for adjudication. This is so because jurisdiction is the very lifeline of judicial power, without which any proceedings would constitute a nullity, however well conducted. Indeed, jurisdiction is everything. Without it, a court has no power to take one step in the proceedings beyond merely declaring that it lacks jurisdiction. See the cases of Madunkulu versus Nkemdili, Rozek versus ACB Limited, citation supplied. It is equally trite that in civil jurisprudence, where the issue arises as to whether or not a court has jurisdiction to entertain a suit, it is the claimant's claim that must be examined in order to find an answer. See the cases of Tuko versus Government of Gungulu State, Adeniyi versus Okpayori, and Nigboro versus Seed Trucks Nigeria Limited, citation supplied. See also the cases of Godwin versus Ekwe, CBN versus Okoji, United Cement Company Nigeria Limited versus Akpampa Local Government Council, Ahmed versus Ahmed, cited by the claimant's counsel. So in the instant case, the court must restrict itself to the facts deposed by the claimants in the statement of facts and the relief sought in determining the issue of jurisdiction. At this point, at this juncture, permit me to resolve the preliminary issues raised by respective counsel in the written addresses. In his written address, counsel for the claimants argued that by Order 3, Rule 10, Sub-Rule 4 of the Rules of this Court, it is required for the defendants to file a defense and incorporate a special defense, if any. In other words, the arguments of counsel seem that the third defendant ought to have specifically pleaded the special defense, and the failure of the third defendant to file the special defense will be deemed waived. As correctly submitted by counsel for the third defendant in the reply on points of law, the rule of this court in reference does not make such provision. Furthermore, it is on record that as required by Order 18, Rule 2, Sub-Rule 4 of the rules, the third defendant filed a memo of conditional appearance on the 24th of April 2025. Order 9, Rule 2 of the rules of this court also provides that where any defendant fails or omits to file a memorandum of appearance, the delivery of any documents or subsequent processes in relation to the matter shall be deemed good and proper service. See also the cases of Ellen Banjo and another versus Dawodu, Nasir versus CSC Kano State, citation supplied. Therefore, the argument of claimant's counsel on waiver by the third defendant is hereby discountenanced. Counsel for the third defendant, in his reply on points of law to the claimant's written address, argued that paragraph 7, 8, 9, 10, 11, 13, 14, 16, 17, 18, 20, 21, 22, 23, 24, 25, and 26 of the counter affidavits offense Section 115 of the Evidence Act 2011, being legal arguments, conclusions, statements which are not facts that are recognizable to the deponent, and urged the courts to strike out the said paragraphs. The cases of military governor of Lagos State versus Ojukwu, NEC versus Isuogu, Ocean versus Flour Mills of Nigeria Limited were cited inter alia to buttress his submissions. It is strike law that an affidavit shall not contain extraneous matter. See Section 115, Sub 1 and 2 of the Evidence Act, which states thus, I quote, "Every affidavit used in the court shall contain only a statement of facts and circumstances to which the witness deposes, either of his own personal knowledge or from information which he believes to be true. An affidavit shall not contain extraneous matter by way of objection, prayer, or legal arguments or conclusion." End of quote. On when a matter is extraneous in an affidavit, the Supreme Court in General Aviation Services Limited versus Tahaha 2004, all Federation Weekly Law Reports, Part 211 at page 1368, Part Y for GSC, said, I quote, "If therefore affidavit evidence is in the form of conclusion, inference, legal argument, prayer, or objection, it raises no facts which needs to be controverted, but simply regarded as extraneous to the determination of factual disputers." End of quote. The test, therefore, for determining whether a matter is extraneous is to ascertain whether the particular deposition is fit only as an argument which counsel ought to urge upon the court. Once it falls within that category, then the deposition is offensive to Section 115 of the Evidence Act. I have looked at each of the paragraphs in the counter affidavit that are said to be offensive. Firstly, the deponent is not a legal practitioner. Then the following paragraphs, 7, 8, 9, 10, 11, 13, 14, 16, 17, 20, 21, 22, 23, 24, 25, and 26 contain statements, legal arguments, and conclusions that are proper for written address. Therefore, I agree with the submission of counsel that the said paragraphs of the counter affidavit are offensive to the provisions of Section 115 of the Evidence Act. The said paragraphs are hereby accordingly struck out. In his oral submission, counsel for the claimants further argued that Public Officers Protection Act, that is the POPA, and the Limitation Law of Kogi State 1991 are unknown and or inapplicable in Kogi State, and submitted that the said statutes are inapplicable in the instant case. Counsel placed reliance on the cases of CIL Risk and Asset Management Limited versus Ekiti State Government, 2020, 12 Nigeria Weekly Law Reports, Part 1738, page 203 at 243, and the cases of Suleiman Dauda versus Kogi State Polytechnic and other in suit number NICN/LKJ/33/2020, judgment of this court delivered on the 28th of July 2022, and the case of Mahabamaye versus Polaris Bank Limited and another in suit number HCL/52/2025, ruling of the High Court of Kogi State delivered on the 3rd of February 2026, and urged the court to hold that the limitation law Kogi State is non-existent and that POPA is inapplicable in Kogi State. In response to the oral submission of the claimant's counsel, counsel for the third defendant submitted that the objection, that is the instant objection, is grounded on Section 2A of the POPL Supra, which remains applicable in Kogi State by Section 4 of Decree number 41 of 1991, States Creation and Transitional Provisions number 2, Decree 1991. Counsel further submitted that pursuant to the said decree, all existing laws in the states, in the instant case, Kwara State and Benue State, out of which the new states, including Kogi State, thus created by the decree, shall continue to have effect in the new states, thus created, subject to such limits and modifications as may be necessary. The decree came into force on the 27th of August 1991. The further submission of council is that by Section 315 of the Constitution of the Federal Republic of Nigeria 1999 as amended, the POPL Supra is an existing law, and such law shall continue to exist until it is expressly repealed. I must be clear and stating that the case is only an authority for the facts before it and similar facts arising from subsequent cases as precedents. COKK versus Uwa China, Skybank versus Akinpelu. The implication of this is that once the facts are not materially the same, the court is not under obligation to follow the decision earlier decided by a court, either as persuasive or binding precedent. Bearing this in mind, it is important to focus on the salient, interesting points the counsel for the objector is making, that the objection in the instant case is hinged on the provision of the POPL, which is an existing law in Kogi State pursuant to Decree number 41 of 1991, and by virtue of Section 315 applicable to Kogi State. Just a minute, please. I have painstakingly examined the authorities cited by the claimant's counsel with regards to his arguments. As correctly submitted by counsel for the third defendant, the instant objection is hinged on POPL and not POPA as assumed. Reference was not made to Decree number 41 or the applicable of the said decree to the newly created states in all the authorities cited by the claimant's counsel. In the instant case, I am of the firm view that the facts in seal risk and asset management case is not the same as the facts of the present case, and this court is not bound to follow same. And as a whole, in the same vein, the authorities of courts of coordinate jurisdiction are persuasive, and this court is not bound by the authorities of the courts of coordinate jurisdiction cited by the claimant's counsel, and I so further hold. Now, the simple and narrow question to be determined in the present objection is whether the provision of Section 2 of the POPA Supra, the limitation law Supra, are applicable to the facts of the instance case to oust the jurisdiction of this court for being statute barred and liable to be dismissed. The intent of the doctrine governing the calculation of the limitation period as encapsulated in Section 2A of the POPA or POPL, as in the instant case, is to preserve the orderly administration of justice and law on limitation period for bringing an action against a public officer is settled beyond doubt by a plethora of judicial authorities. The general position of the law is that time begins to run for the purposes of the limitation law from the date the cause of action accrues. C. Ajayi versus Adeniyi, Soulgrave Holdings Incorporated versus FGN, citation supplied. In the famous decision of Thomas versus Olufosoye, 1985, 3 Nigeria Weekly Law Report, Part 13, page 523, a cause of action is said to arise and accrue to the person entitled to it when the facts or all the facts are complete, which entitle a person to a remedy against another if proved. The case of the claimants, as disclosed in the statement of facts, is that they were employed as officers by the fifth defendant on different cadres at different times from the 29th January 1979 and 2000 and the year 2000. However, they alleged that the third and fifth defendants under the guide of the first, second, and the fourth defendants arbitrarily stopped their salaries and allowances in the month of September 2009 and still continue without a just cause till date. The claimants contend that without ever being indicted for any wrongdoing or invited for investigation on any subject matter, their names were arbitrarily removed from the payroll and without first determining the subsisting employment relationship. The claimants also allege that their employment still subsists with the defendants. As I earlier stated, the argument of the claimants' counsel in reaction to the objection is that limitation laws do not apply to action founded on rights enshrined in Chapter 4 of the 1999 Constitution or acts founded from malice, abuse of powers, illegal action of officials, or wrongful actions such as arbitrary withholding of salary or cases founded on contracts. The claimants' counsel also argued the acts of withholding the claimant's salary without the determination of their employment is a continuing injury. An action falls within the exception of continuing damage, rendering Section 2A of the Public Officers Protection Law applicable to the instant case. In response to the argument, the claimant's case falls within the exception of the continuing damage or injury, counsel for the third defendant in his reply on points of law distinguished between a cause of action and a continued damage or injury. That a cause of action is a factual situation, the existence of which entitles a person to obtain a remedy from a court against another person, whilst a continual damage or injury is the continued act of omission or commission or injury and not the continuation of the effect of the act, injury, or damage. Counsel cited the case of INEC versus Ogbadibu, local governments, and others. 2015 Law Pavilion Electronic Law Reports at 24839. This same position was held in the cases of Al-Hassan versus Aliyu, 2009 Law Pavilion Electronic Law Report at 834, and the case of Oludele versus Wema Bank PLC, 2014 Law Pavilion Electronic Law Report at 23389, and the case of Bukana and others versus Nigeria Security Printing and Minting PLC, 2016 Law Pavilion Electronic Law Report 51206. Proceeding on this legal footing, therefore, it is clear from the averments in the amended statement of facts particularly paragraphs 2, 10, 11, 14, 17, and 18 thereof, that the alleged acts, that is the course of action, is that their names were arbitrarily removed from the payroll, which resulted in the stoppage of their salaries. The act of the removal of the names of the claimants from the payroll crystallized and was completed in September 2009. Put differently, the course of action in this case is not continuous, and the exception in Section 2A of the POPL with respect to continuous damage or injury does not apply in this case, and I so hold. Perhaps I should remark that in paragraphs 21, 22, 23, 24, 25, and 26 of the amended statement of facts, the claimant stated that a notice of intention to sue was served on the defendants on the 31st of August 2010. That the claimants filed two suits, suit number OH/05/2011 and suit number OHC/07/2011 at the Kogi High Court, Okpo, that the judgments on issue of jurisdiction were set aside on the 10th of December 2019. The same was affirmed by the Court of Appeal on the 3rd of January 2024, and that other efforts they made to resolve the disputes with the defendants proved abortive. From these facts presented by the claimants in the foregoing, it is unassailable that the course of action had accrued since September 2009, or why will they have gone to the courts if the course of action had not accrued at that time? Now, I am not unmindful of the fact that the apex court has oscillated over the years as the question whether the limitation law, of which POPL is one, applies to employment contracts. Permit me to bring to fore the Supreme Court cases on the recent past. In National Revenue, Mobilization, Allocation, and Fiscal Commission, and two others in Ajibola Johnson and 10 others, 2019, two Nigeria Weekly Law Reports, 1656, page 247, after reviewing the older authorities, held that the limitation law does not apply to employment contracts. However, the conflicting decision emanating from the Superior Courts of Record of this country on the issue has been rapid. Counsel for respective parties have elaborately furnished some of these decisions. The most recent decision of the Supreme Court on the vexed issue of the applicability of the POP and the limitation law is the case of Okonkwo versus INEC, 2025, 8 Nigeria Weekly Law Reports, Part 1991, at page 131. In that case, it was held that Section 2A of the Public Officers Protection Act, Supra, or limitation law, POPL, applies as in POPL, as in the instant case, applies to contract of service. Thereby entitling the defendants to exercise their statutory rights and duty. The doctrine of judicial precedence, otherwise known as stare decisis, is not alien to our jurisprudence. It is a well-settled principle of judicial policy which must be strictly adhered to by all lower courts. While such lower courts may depart from their own decisions reached per incuriam, they cannot refuse to be bound by decisions of higher courts, even if those decisions were reached per incuriam. The implication is that a lower court is bound by the decision of a higher court, even where the decision was given erroneously. See the cases, CBN versus Lokoja, 2015, 14 Nigeria Weekly Law Report, Part 1479263. In Atolagbe vs. Awuni, 1997, 9 Nigeria Weekly Law Report, Part 522 at 564, who weighs CJN as it then was, stated thus, I quote, "It is now settled that under the common law doctrine of precedent or stare decisis, the decision of a higher court may be criticized by the judge of the lower court, but notwithstanding the criticism, the judge of the lower court is not bound to follow and apply such decision in the case before him. He has no right to disregard the decision or sidetrack it," end of quote. This principle was recently restated by the Apex Court in Wema Bank PLC versus Awotunde 2025, 18 Nigeria Weekly Law Reports, Part 2017 at 273. Limitation of action principle is both statutory and equitable rule of law applicable in international and national laws. One of the principles of the statutes of limitation is that a person who sleeps on his rights shall not be assisted by the courts in an action for his claims. A person who is aware of his rights or allows them to go still should not be allowed to revive the stale action to the detriment of an adversary. It applies to make claims inadmissible if a party waits for an unreasonable period to bring the claim, thereby prejudicing the defendant's ability to defend. It is similar to the equitable principle that equity aids the vigilant and not the indolent, and it prevents a party from acting unconscionably. See Wadiero versus Shell Petroleum Development Company Limited, 1990, Nigeria Weekly Law Report, Part 150 at 322. In Skybank PLC versus Perone Nigeria Limited, Samani JCA opined thus, I quote, "Statutes of limitation are enacted so as to prevent or avoid a situation where a plaintiff who has slept over his rights may wake up from his slumber at any time to commence an action in respect of a right which has accrued to him. Such limitation statutes are founded on principles of equity and fairness, and therefore, in keeping with the equitable principle of equity aids the vigilant and not the indolent person. A person who has decided to hibernate while his right is being violated cannot wake up at his leisure to commence action to realize such rights. The rationale behind such statute is that a plaintiff should not be allowed to perpetrate injustice by keeping a defendant in suspense ad infinitum, end of quote. On the basis of the foregoing analysis and based on the principle of stare decisis, which this court is bound, the decision I have arrived at is that the filing of the complaint 17 years after the act complained of clearly offends Section 2A of the Public Officers Law Super. I find in the results that this court lacks jurisdiction to entertain the suit. The same shall be and is hereby accordingly dismissed. Parties shall bear the respective costs. Ruling is hereby entered accordingly.
As the court pleases. My lord, we, on behalf of the third defendant objector, my lord, we thank the court for the well-considered and very thorough ruling. We are most grateful, my lord.
Yes, thank you. The ruling shall be transmitted somehow by next week. What's today? Today is just Monday, is it?
Yes,
before the end of the week, the ruling will, and the files and all your authorities will be sent across to the Lokoja division by God's grace. Thank you. The court will rise. Thank you.
I'm most grateful.
I'm most grateful, my lord. I'm grateful. No, not the rising.
Mr. Albaido,
Congratulations, sir.
congratulations. I greet you. Well done.
Hold on, sir.
Are you in Abuja or in Lokoja?
I'm in Lokoja. I'm in Lokoja.
Okay. No problem. Okay, now take care. Bye. Bye.
Congratulations.